The next case to come before the court is Teresa Vintantonio v. American Construction Group et al. You will have up to 15 minutes to present your argument. The arguments are being recorded, so please stay behind that podium and keep your voice up. Don't use the names of children or minors or victims during your argument should that be relevant. You can certainly use general terms. The judges have read your briefs and we're ready through your brief, and we are ready to proceed when you are. So you have 15 minutes.
Thank you, Your Honor. I think the relief sought here is pretty simple and narrow, simply that there was a finding in the trial court that the defendants breached the settlement agreement, and yet the trial court cited authority for the proposition that there's a requirement that we prove bad faith in order to recover for attorney's fees. And so the sole narrow issue on appeal is whether this case should be remanded for a damages hearing on attorney's fees.
So tell us why it should.
Well, I think that, as outlined in my brief, the point of settlement is to create finality. And this has been long, ongoing litigation. There was a $10,000 liquidated damages award that really shouldn't have even had to go to the trial court in order to be paid. And even as I stand here today, that $10,000 still has not been paid. This particular defendant is sort of a frequent flyer in the court system, and so, my client never would have entered into a settlement agreement if she knew that he could basically flout the terms of that settlement agreement and walk away scot-free. That was part, sorry, go ahead.
I just want to make sure that when we're presenting, we stick to what we're going to be able to see on review.
Sure.
In this case, okay?
And so I think if you look at the testimony at the hearing from the plaintiff, and I would need to defer to what's written in the transcript, I think there is some questioning along the lines of, had you known that he would breach this agreement, would you have signed it? And the answer was no.
So your assignment of errors is pretty legal. You're saying that the award, the trial court erred by determining that the attorney's fees couldn't be awarded to a prevailing party if there wasn't bad faith.
That's correct. I think it's solely an issue of law. I would argue that there is also bad faith, but...
Okay, so you're... What is the standard if it isn't bad faith?
I think the standard is set forth in the brief, which is basically that a settlement agreement is different than a typical contract, where attorney's fees are not costs that can be awarded according to the American rule. And now several districts within Ohio, as well as the Northern District of Ohio, have said this is different, right? That you enter into a settlement agreement thinking that you've gotten a certain benefit of the bargain, and that when the defendant subsequently breaches that settlement agreement, which in this case the court found that he did, your damages are the costs that you incur having to enforce what it is that you already agreed to.
What about the liquidated damages provision?
Is the question about whether she should be awarded attorney's fees for enforcing the liquidated damages provision?
You have in your contract a provision for as a penalty, right?
Yes.
Okay. Why does that penalty not include any attorney fees? Because you've already negotiated between the two of you what's going to happen if there's a breach of this settlement agreement. And you agreed that there would be a liquidated damage amount. So why does that not take care of the attorney's fees?
I believe if you look at the actual settlement agreement itself, there is a provision, and this was brought up at the hearing, that contemplates something above and beyond the liquidated damages. And I'm going to try to... And so on page 4 of the trial court's order, there's an excerpt from the settlement agreement where it starts by saying that if they fail to perform the work as required, they will pay the plaintiff the sum of $10,000 in liquidated damages. That portion of the settlement agreement was to penalize the defendant from not completing the work, but we can provide a notice and cure period. And then if you look at the last sentence of the settlement agreement, and this was negotiated by myself with opposing counsel, the foregoing liquidated damages are not plaintiff's exclusive remedy for American Construction Group LLC's failure to timely complete its performance obligations, and the parties agreed that the plaintiff may seek specific performance to separately protect her from the damages that she would incur if the defendant abandons the work or fails to provide the release.
Thank you.
And I guess just to elaborate on that, the work wasn't done, and so there was a penalty provision in the form of liquidated damages. Not only was work not done, it was abandoned. And so we then had to separately protect my client's rights by going and saying, you know, we're going to seek specific performance, and we need to enforce the fact that there's a $10,000 liquidated damages provision that was not paid. And the trial court denied specific performance, but certainly agreed that the defendant had breached the settlement agreement, and I don't think there's any dispute that the $10,000 is still unpaid.
What did you file with the court?
I'm sorry, at which stage?
What did you file here to enforce the settlement agreement?
The relief that the plaintiff is seeking is simply to reverse the legal decision of Judge Bro.
Yeah, I'm asking what you filed in front of Judge Bro to get this in front of us. What, I can go back and look, I just can't remember off the top of my head. I thought you would know.
I have simply filed a notice of appeal. So
I'm not talking about us, I'm talking about in front of Judge Bro to try to get enforcement of the settlement agreement as well as to get the attorney fees.
Oh, Your Honor, I have filed a motion to enforce the settlement agreement, and I believe for sanctions, it would be in the trial court docket.
Okay.
That's what sort of precipitated the evidentiary hearing.
The reason I asked that was, and I guess I could have just come out and just said it directly, did you allege any type of bad faith?
Your Honor, at the evidentiary hearing, we did.
Well, okay. Did you allege it first in your motion to enforce?
Your Honor, I would have to go back to the motion. I don't recall off the top of my head.
And you're saying you raised it at the evidentiary hearing, saying specifically that this was done in bad faith?
Your Honor, I think it's the same argument that I'm making today, which is in the first instance, the law doesn't require a showing of bad faith.
Right.
But if there is a requirement that there be bad faith, there was bad faith. If this hinges on, honestly, Your Honors, if this hinges on whether there's bad faith or not, you know, that becomes a factual issue that's probably gives deference to the trial court. And the reason I'm bringing this appeal is to clear the case law in this district on whether parties who agree to a settlement agreement can simply walk away and not be held accountable for the attorney's fees that the opposing party has to incur in order to enforce their legal rights.
Well, they don't walk away if there's bad faith, right? It's okay.
I'm sorry, I just...
That's all right, we'll take a look at it.
Okay.
Any further?
No, I'm fine.
Okay.
Anything further? Thank you so
Thank you.
much. Thank you so much for
Appreciate
your
it.
presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. Thank you again.